Good evening and welcome to Realty Coffee Talk on Awaz Entertainment. My name is Tahir Qureshi. I'm your host for tonight. The topic of our show tonight is legal issues in real estate. Before we begin our program, introduce my guest. Coronavirus has affected life of our Canadian citizen. We wish and pray for their safety. We will be discussing the impact of coronavirus in our discussion tonight. So first of all, it's my pleasure to introduce Mr. Raza, a prominent lawyer and community personality in Mississauga. Brother Raza, welcome.
Good evening.
I would like you to introduce yourself to the community. So if you take a few minutes to introduce yourself.
Absolutely. We are living in exceptional times right now because of the COVID-19 issues, but that should not mean that we should stop our normal life and our normal economic activities. We have to use caution and care, but then the life has to go on in the best manner possible. So, Mr. Qureshi, thank you for inviting me here.
You're welcome.
And hopefully our discussion will be of use to the listeners and the viewers.
The purpose of Realty Coffee Talk is to increase awareness and consumer trust in real estate. As you know, coronavirus is impacting our life in Canada, so I think we should begin on coronavirus impact on transactions and contracts or agreement of purchase and sale that has been executed, but there are people who are not available to go to the offices. So how do you see it will impact the buyer and sellers as a legal point of view?
You know, you raised a rather interesting question, because this question has been discussed in our offices, certainly in my office, because of the, I would say, exceptional circumstances through which we are going right now. Number of people are reconsidering the completion of the contracts that they have signed and then entered into. And one of the arguments that was suggested by one of the lawyers in my office, by act of God, meaning this is such an exceptional development. I do not recall in my 40 years of practice anything like this happening, where not even the general offices are closed, but even the courts are closed. A lot of my work is in the courts, and even those are closed. So it is really quite exceptional circumstances. Does it mean that this exceptional circumstance allow us to give us the right to break a contract? I think that area is going to be debated in the next few days. And I think some lawyers are taking that position that, as Mr. Qureshi raised that question, whether these agreements that have been entered prior to the declaration of emergency, both in Canada and in the province, can we walk out of a contract? I believe it is possible if it is a material circumstance. Material meaning, does the COVID impact upon my contract, upon the terms of my contract? Say, for example, I can give you a live example that, in fact, I have been currently confronted with this morning, a situation of my client purchasing a restaurant. Because of the emergency declaration and because of the COVID-19 situation, a restaurant will not be allowed to function and operate as a restaurant, because people will not be allowed into the premises and they wouldn't be able to sell any product. Does it then allow my client to, at this time, terminate the contract? We haven't determined yet as to what position we shall take, but one thing we definitely have decided, and we have already approached the lawyers for the sellers, that perhaps we should delay the transaction. That's a midway.
In
So,
this,
Mr. Qureshi, I don't know if it answers your question.
I have a issue, a question about it. A delay of closing because of virus by third parties. What are the third parties who can enable both parties to close? For example, mortgage is not arranged, bank are not available, title insurance is not there. I heard about some kind of a gap closing, some kind of arrangement that Law Society is introducing something.
Title insurance has a provision where they cover you for the gap. Say, for example, the transaction was scheduled to close on the, say, give and take, what is the next week, Monday? Today is the 19th, say 24th of March. And it was originally scheduled to close today. Or pardon me, coronavirus appears today, and because of that, there's delay in the closing. And the closing extended not on the 24th, but happens, finance is unavailable. The person who is selling the property is unable to vacate the premises. Title insurance will provide coverage for that period.
So would you recommend that we should have some kind of automatic clause? For example, at the time of closing, the buyer or the seller is quarantined and they cannot come over and sign the paper. So would there be some provision in the contract that we should allow either delay on third party or delay of any reason from both sides, or if they are quarantined because there is an emergency declared by the province of Ontario?
There is no such provision in the standard form agreement at this time. But there are discussions going on both within the Law Society. Law Society, for example, yesterday permitted that we can witness the signature by our clients by way of video.
Video, yeah.
And so that is, they have not discouraged it, but they have said that is one way of doing it. Title insurance companies themselves are debating this issue, whether we can do it by way of electronic signing, as you know that many of the realtors use electronic signing in the agreement. Yeah. But it has not been used so far, but I think that will become available in the next few days.
So basically, in this case, I would suggest that people who have executed agreement of purchase and sale and they are represented by realtor, they should approach the legal counsel, get their advice, and also speak to the realtor who is representing the seller to make sure there is understanding. This is a very extreme condition. As you know, our Prime Minister injected almost $85 billion to support all this businesses and the public. So this is a very extreme condition right now.
It is a very exceptional situation. And my question that I have raised in my own mind, in fact, today, well, that we are buying a property. I'm the buyer. The seller who's living in that property until today, before the closing, had been infected with coronavirus. And I have become aware that the seller had been infected with coronavirus. Do I have a duty to close the transaction because it exposes me to possible infection as well if I take possession of the property?
Yeah.
And that question, it has occurred only in my mind. None of my colleagues had ever thought of it, so I really don't know which way we are going to determine that question. I think the buyer has the right not to seek the termination of the contract, but certainly seek delay in the contract until the property can be the contamination can be removed from the property.
Yeah, is being a good fellow citizen and working honestly and faithfully executing the commitment they have made. And this emergency came in and it's affecting everybody, not just one,
absolutely.
Across Canada.
Absolutely.
Being a good Canadian, I think that we all have to work together to make sure that the transaction take place and get advice from your legal counsel who is involved with the transaction. So this is extreme condition, but it goes back to really when you are signing an agreement of purchase or sale, there is a transaction between buyer and seller, then you are having a representation agreement where some contractual documents and how important they are and what are the really main component or definition of a contract that people are committing when they're signing these documents. So can you enlighten us a little bit on that?
In very simple terms, these buyer representation and seller representation agreements really are agency contracts where the agent accepts certain responsibility on behalf of his principal. The principal is the party who is either buying. In the case of a buyer representation agreement, the buyer is the principal and the agent is the agent of the buyer. And same thing is true in case of seller representation or the seller's agreement. The agent represents the seller. And once you sign that agreement, it's a contract. It's a written contract. Both parties are bound by it. I have almost invariably recommended to my clients in either of the situations, seller or buyers, that before you sign those agreements, have them reviewed by a lawyer, especially if you're a new buyer, meaning you have not experienced buying or selling in the past. The result is that regardless of what you may say, that agents might tell you, the realtors might tell you, oh, it's a simple contract, I'm going to represent you. But don't forget, it has legal value. You're bound by by the terms of that agreement. And anything which has legal binding issues, it is best that you have it reviewed by your lawyer. It creates responsibilities both towards the buyer, the principal, meaning the buyer in this case or a seller, and the agents representing them. It creates legal obligations on part of both parties. And it is therefore important to recognize it, that the legal obligations. In case of the agent, in fact, the agent's responsibilities goes beyond that written contract, be it the buyer representation or seller's agreement. There is a principle in law which is called the fiduciary duty. The fiduciary duty creates additional responsibilities for the agents. Mr. Qureshi would be quite sensitive to that.
Yeah, absolutely. Yeah, that was my actually next question that you already picked up.
There you go. This question is really a part of that agency agreement.
Yeah, because I'm looking at the agency problem and fiduciary duty. That was my next question.
Yes.
That how it contradict and create problem when a representative does not follow through the fiduciary duty. So,
you know, in very brief term and very simple way, and the way that I like to work, I like to simplify things.
Yeah.
So that everybody
that's why we are trying to.
Yes. You know, there are only few simple duties that an agent has, Mr. Qureshi.
Yeah.
First of all, that he is subject to the control of the principal, meaning the person who has retained him.
Yes, yes.
Number one, very simple.
Yeah.
Number two, the agent has to act within the ambit of the authority that he's been given. Very simple as that.
Simple as that,
If
yeah.
I have been given the authority to buy, say, for example, this particular cell phone, that I am the agent, and I am only authorized to buy this cell phone, nothing beyond that. I can't buy Mr. Qureshi's cell phone. This is my authority that has been given to me. The third duty is to discharge his duty with due diligence and with sincerity, with care, avoiding negligence. Meaning, why do I hire an agent? Because the agent represents that he has certain expertise in that area. He must use that special skill and expertise to serve the interest of his principal. That's very important, because then that duty, the fiduciary duty, also essentially an extension of that duty.
Yeah, to protect actually the client interest.
Yes.
That's a part of the fiduciary duty, to protect the interest of the client.
Yes. And so it is important that the agent recognize it, that he is subordinating his interest to his principal's interest. That's of critical importance. That's what fiduciary duty in the spirit means, that I as an agent am subordinating my interest to the interest of my principal. Even if I see it's possible that it is not to my best advantage, but to the advantage of my principal, then I must do that because it's to the advantage of my principal.
Yeah, I will just clarify that under the law, a brokerage could be a corporation, a partnership, or sole-proprietor brokerage. All realtor is a trademark. The real definition of REBA, which is now Teresa, Trust and Real Estate Services Act, which is new law coming, changes are coming, is that everybody who you call a realtor are working for the brokerage, which is registered with Real Estate Council of Ontario. So they are working on behalf of the brokerage, and brokerage is the one that is signing contract with you, represented by the salesperson, broker, or broker of record in real estate. I just want to clarify that,
yes,
because
absolutely.
Lots of people think that realtor is not a license. It is a trademark of Canadian Real Estate Association. So you must see a license. Everybody carry a license. I carry my license as a broker, that when performing the duty under the law, that you know that the brokerage is registered and also salesperson or broker is registered. So that brings me to the issue is fiduciary duty. We hope that everybody's practicing, they are trained. The best solution is to seek education and training. If you lack knowledge, understanding the fiduciary duty, you talk to your broker of record and you learn your fiduciary duty and get all the training. It will help you do your job better. Now this also brings you another subject where commonly people have talked about and complain about misrepresentation by realtors,
yes,
or by the seller or by the buyer. So it has to do with the error or misrepresentation or fraudulent intent. So how would misrepresentation, you feel that can cause problem in dealing with real estate?
The issue of misrepresentation is in fact one of the very complex areas of litigation.
Yeah.
And first thing that we need to divide it and say, is it a material misrepresentation? Is it merely say that, oh, when, you know, it could be something very minimal which has no impact upon the transaction? Then that would really not be a material misrepresentation. But material representation would be one which would impact upon the transaction for the parties involved in the transaction. It is, if it is even a less serious form of misrepresentation, but if it is done with an intent to deliberately or by recklessness or callousness not to protect the interest of your principal, then it would be definitely create liability against the agent. It happens quite frequently, frankly speaking, for several reasons. One is, of course, some of the agents are not as well informed, not knowledgeable, and when they're not knowledgeable, they make some rather wild claims, wild statements, and those statements can come to haunt them because those statements will really become misrepresentation on the part of the agent. On the part of the client, that's a little bit more difficult, the area of misrepresentation. In fact, a few years back, this was somewhat common practice by the realtors. They used to have what is called those seller's property information
sheet, yes.
Receipt.
Seller property information sheet.
Those were representations made by the sellers, by the party itself, and those became a source of countless disputes and litigation. And I think in the recent years, the use has been almost eliminated by the realtors.
They don't use that.
Because it used to cause or raise these issues of representation on the part of the party or the principal himself. But if the representation on the part of the agent, even if it does not cause loss to the principal, is still actionable, and the agent may still be held responsible in damages, even if it does not cause any loss to the principal, because it's deemed to be a very serious violation on the part of a professional. Same is true of lawyers as well, indeed. If they misrepresent to the client, they could be open to...
Yeah, in our MLS system, I noticed that sometime the information talk about square footage.
Yes.
And they sometimes include basement square footage in above grade. The value of the above grade is different than the cost of the basement square footage. So people have many times apprehension that the professionals are not paying attention and disclosing information, because value of a above grade could be $400 per square foot, yes, whereas the basement is originally part of the land that you already got from the builder. And the cost of renovation could be, basement would be about $40, $50, depending on the average house, versus $400 for the above grade.
Yes.
So this fall into misrepresentation and a rise for a legal case against professionals or the seller?
Yes. Let me share something with you. In fact, in the MLS listing, there is more detail than in the agreement, because the square foot is there, the number of rooms are there, the kind of washrooms are there, whether they're tiled or is hardwood, everything, a lot of stuff is there.
Yeah.
Lots of people don't realize that it is possible to make the MLS listing as part of the actual contract. And if you find a serious deviation, which could, if the purchaser has relied on the MLS listing and what is provided in the MLS listing, and in fact when he actually completes the transactions, you find it is lacking.
Yeah.
It would be definitely a cause for an action against both the seller and the agents involved, both agents, the seller's agents and the purchaser's agent.
Now here's another interesting question come to my mind, is that when agreement are prepared and offered, seller agents say, we take no responsibility or warranty in terms of what is being provided as a marketing material. And I believe our regulator has taken exception to that, because you are licensed to practice real estate and you present the fact and take responsibility what you're doing, because you're being paid reasonably. So what do you think about that?
See, this is an aspect of representation. When I do the MLS listing, I may say, no, it is there, it is, you have to do your own due diligence, the buyer beware, and caveat emptor. You can argue all of those things, indeed so. But that is a representation. If the innocent purchaser for value has relied on that multiple or party does MLS listing, then what do? I'm an innocent buyer, I'm paying good money, relying on the authenticity and the truth of the MLS. I believe a very good argument can be made in court that the agents and those who have produced that MLS listing and those who have provided the information in the MLS could be held liable. The courts and judges, while they do rely on the written agreement, are often willing to stretch themselves to protect an innocent buyer, innocent party. The agent should be aware of that fact, that jurisprudence is moving towards, from a strict law, to a bit towards justice as well.
Yeah, I always suggested to my clients and buyer or seller to put their expectation, what they expected of me and what I expected of them in performing duties under the law, to write down in Schedule A all the details those are the ones that they expect you to perform, so yeah, you can have a successful transaction when you executing their instruction, which is a part of the agreement of buyer representation agreement or seller representation agreement. What do you think about that? It should be included there?
You know, I have had serious issues with some of those things because now some of the agents have become so cautious and careful that they even list the number of keys that will be available.
Yeah.
The element of good faith has been significantly diluted in the modern commercial environment. It's very sad, because people do have, they rely on good faith of the people they're dealing with, the people that they're working with, meaning the agents, the brokerages, the sellers. They would have liked to rely on those, but that good faith thing has become significantly diluted. Can the agent or should the agent put all those details? I've seen some agreements which actually even list the what do you call those on those equipment and home, the serial numbers
of refrigerators, you talk about chattel
stoves that actually list the serial numbers. You know, I find it a little disappointing that the human relationships have been reduced to an extent there is no reliance at all on each other. But perhaps to be extremely cautious from the point of view of a lawyer, avoiding litigation, avoiding troubles for everybody involved. If you can have a very detailed agreement, setting out all of those things, the kind of equipment that you have on the property, the number of queues that you have on the property, maybe one of the things that they can do, which could simplify all those details, take pictures and make photographs as a part of the schedule to the agreement. I think you may think it's pushing it too far, but if you want to avoid litigation, avoid misunderstanding among the parties, then maybe that's the way we are heading.
Yeah, it's very challenging, and we have to make sure that we're doing our job right, have good understanding, good rapport with your realtors, cooperate with each other, be honest and upfront, then you have a less problem. Now here's another thing. There's 6 years ago, one time I was working with a transaction in real estate, and the buyer at night, almost 11 o'clock, brought me an offer, and they want this house, and they added a central air conditioner which was not included in the house. And it was so thin that I can't read it.
Yes.
You know, and I luckily I noticed that, and then I strike it down. So we're going to take a break, and then we're going to continue our Realty Coffee Talk.
Dame Drops told us how good Popeye's buttermilk biscuit shrimp is without us even asking.
So crunchy, buttery, just like those biscuits. Are you hungry yet?
8 shrimp, a side, and a biscuit for just $6.99.
At KM 9000 sang about Popeye's buttermilk biscuit shrimp because he was feeling it.
Shrimp, 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 shrimp. Shrimp, 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 shrimp.
8 shrimp, a side, and a biscuit for just $6.99.
Hello, we are back after break, short break. We were talking about when on MLS, if your colleague has listed details about the property available for sale, and if some component is not there that your client wants to have it, then it's very important for you to consult with the listing agent to make sure that chattel is included or not included. Normal cases, we all list items, they are included, and some item may not be included. So please make sure, do not create a new item which is not part of the house and is not listed and put in an agreement of purchase and sale. And in this case, the seller may refuse your offer. In my case, we were able to solve that problem, but make sure that when you prepare your offer, you check the details, compare with the MLS data, and then you insert your chattel in the agreement of purchase and sale. So now this brings you to the false and misleading advertisement.
Yeah, Mr. Qureshi, what you just spoke about, can I add something
Sure, please,
to it?
please.
See, what is the purpose of a contract? The purpose of the contract is to provide clarity in the transaction. Clarity means what? Avoidance of confusion, detail of the product that you're buying, the property that you're buying, the content that you're buying, and the accuracy of the description of the property and the content. I'll give you a live example. That's one of the very few cases that I actually did lose, where the property was a very large property, which had a huge backyard bordering on a ravine. And it was a sloping piece of land at the back. What used to happen that during the snow season, especially after the snow started melting and during heavy rain, there used to be ponding in the backyard.
Oh, yeah.
Because it was bordering on the ravine.
Yeah.
In fact, the ponding on occasions became very much deeper. It was not actual ponding, but it literally became flooding. The agents made the buyers aware that yes, there would be ponding during rainy season, but they did not describe the extent of ponding that it could become flooding. In fact, the very first winter, the buyers who had purchased that property experienced that flooding, and there was literally knee-deep water in the backyard in the sloping area. Guess what happened? They brought an action against the seller. And believe it or not, seller in fact said, well, I notified them that it's ponding. We pulled out the definition of what ponding means in all kinds of dictionaries. We brought an expert. The judge didn't buy it. He said, in common language for an ordinary person who's buying a home, it was much more than ponding. And when you mentioned ponding, that was not adequate description of the potential problem. So you see, Mr. Qureshi, what can happen if a slight misdescription of something that is associated with the property. So, I just wanted to highlight that.
No, I really appreciate that. There is a common complaint in public, or sometime public demands some compensation from the realtors, or realtors offer some inducement to make it a listing agreement or buyer representation agreement. Is that inducement that, according to the law, if you can give it to your client who has signed BRA or listing agreement, is perfectly legal, but you cannot give inducement to or referral fee to other people. Is the inducement as an element of securing an agreement, securing a BRA, listing agreement, or agreement of purchase and sale, can save them if there is a breach of contract? It's very complex.
First of all, my personal view on inducement to the parties to the contract, in my view, is very poor practice. Yeah. Because essentially what it does, it changes the nature of the contract. It changes the nature of the contract. It changes the consideration of the contract. Am I buying the property or buying that asset because I'm been given a certain inducement, or I'm buying the property because I really want to buy that property. So it, in a certain sense, changes the nature of the contract. But if indeed that inducement has been given, then it is a contract between the person who provided the inducement and the person who accepted the inducement. A contract does not need to be in writing. The contract can be verbal. And that inducement contract, unlike a contract for property, a contract for property and land has to be in writing. The statute of frauds is clear for hundreds of years. But an inducement is not a contract which relates to the property. It is strictly a monetary agreement. I promise to pay you X number of dollars or X kind of value of something. Oh, I'll give to you the best kitchen set as a part if you buy it, if you complete this agreement. It is enforceable regardless of whether it's in writing or not writing. Whether it will be enforceable if there's a breach of contract, meaning if the transaction is not completed, then I suggest to you it may not be enforceable. It may not be enforceable because the consideration for that inducement, for that contract, has been lost.
That's right, correct. I think the most important thing is to focus on value for your money. Don't take away the motivation of your representative who is working hard to deliver a value for the money you are spending. So focus is to get the property, because property adds price that justifies based on the market condition. So you are taking away the motivation of the person who's helping you to do get you a good deal, and then you are paying him less. That would
reducing the commission and brokerage has become. I remember I've been practicing for 40 years. In the earlier years of my practice, I don't recall very many instances where the agents or brokerages were willing to reduce this standard commission. But in the last 15, 20, 25 years, this has become literally the standard practice that you reduce the commission. Does it take away from the agent's ability to perform or give his full service because of the reduced commission? I'm not so sure that is true, because the property values have increased substantially. And because of the substantial increase in value, even with the reduced percentage of commission, the brokerages are making fairly good money. Number one. Number two, the process of buying and selling has become, how should I say it, a little bit more easy, in the sense you don't have to go through same kind of hurdles that you used to go 20 years ago. A lot of the information is available on the internet. Lots of the buyers are quite sophisticated. Even before they retain an agent, they have done their homework. They know exactly what they want to buy. It makes the agent's work a little bit easier. A reduced commission, if an agent feels that he has been exploited, then he should not accept that agency. If you accept that agency, even if it's a reduced commission, reduced fee, you still have to deliver your best. That's no excuse. If you say that the motivation has been reduced and therefore I'm going to work less hard on this transaction, is unacceptable.
Yeah, it's just a human factor when you are trying to negotiate your commission more than value of the property you are buying it, but it doesn't release them from obligation under their agency relationship.
When you're talking about the human factor, you should also think about the purchaser's human factor.
Yeah, the important thing to know for you is in Ontario, according to Real Estate Council, approximately 86,000 realtors are in the province of Ontario. I think Toronto Real Estate Board has about 56,000 of them. So all realtors are competing with each other to get your business, also deliver a valuable service to you according to their agreement with you. Either you are a client or you are a customer. There is a difference between the two, one is a client. Normally, listing agent are mostly brokerage or client. But if there are property that is not listed in the market, then the agent who is representing the buyer have to go and ask the private sale property owner to give compensation to bring you the offer. So there are different circumstances, there are different challenges. Yes, there is excessive data availability.
Yes.
The real estate professionals spend years of training, education, continuing education to bring that knowledge and experience to help and facilitate transaction in Canada and safely, because real estate is regulated in the province of Ontario. So that's a very interesting subject and very competitive environment. Now also we talk about now about the material facts about the property. Sometimes stigma is attached, sometimes there is environmental issues, or some people have a major renovation without the permit and the insurance claim. So how we, the realtor, are responsible to find material facts about the property as much as possible. How it will happen if someone discover this after buying, agreement has been finalized, and they discover these are challenges which was not disclosed at that time? How they will deal with the agreement?
It's an extremely difficult area of litigation. I do litigation, so I'm somewhat sensitive to what you are saying. If it is indeed significant material deviation and it has reduced the value of the marketability of the property, then I don't have the least doubt in my mind that it's actionable. Meaning, it is possible to bring an action for damages not only against the seller, but also against both agents, for the buyer agent and the seller's agent, because they have not done their due diligence. Why do you go to a professional? A realtor who is representing you is a professional. He's passed a whole bunch of examinations, his experience, he has had training, he has worked with brokerages who have even more experienced people associated with the brokerages. They're supposed to do their due diligence. What do you mean by due diligence? Due diligence only finding out what the property tax is for that year for that property? Completely inadequate. That's not due diligence. I can simply Google it and I can find it out. Due diligence means you must educate yourself about the property. What has some history of the property? If indeed there is, in fact, in some are publicly known facts, for example, what do you call this? Growing marijuana?
Grow houses.
The grow houses.
Yeah.
There's a record of grow houses with the police. Lots of real estate and don't even investigate that. Unless, of course, there is some hint that it may have been a grow house, then they might go to a police station and get a report. It's a very simple process. The responsibility of a professional is very high. You have to fulfill those duties, not just say, okay, I have done my duty. No, you actually have to demonstrate that you have done your duty. In case of material lack of disclosure, for example, if you had issues on the property, I don't know, in some cases, some issues may not be admitted. Suppose a house has a fire incident, but the fire incident has been fully restored. Meaning that the house has been rebuilt with appropriate building permits, proper permits have been, the clearance have been obtained, the house is back in its original shape, and you don't disclose it to the potential buyer that house had an incident of fire some years ago. Is it material, this lack of disclosure? I would say no, it is not. Because the value that the buyer is getting for that property has not been reduced in any manner. But if the material disclosure reduces the value of the property and the marketability of the property, then of course it will be actionable. No question.
I'm going to ask you a very interesting question. Sometime the buyer, in a hype of a bidding war, give an offer, it doesn't justify the value of the property. It's emotionally charged, and he put the offer. The offer is accepted, but they refuse to give deposit because there is no cooling time in this buying a home versus the consumer when they buy from the builder. Maybe there's a cooling time, I think, for the builder, but the resale there is no cooling time, and he refuses to give the deposit. It put embarrassing for the buyer representative, and also it holds the property for 5 days because mostly conditions are for inspection and financing. What do you think guidance to the realtor, what they do?
Let me restate the question. A has purchased a property. He has signed all the agreements. All the conditions have been removed. And
no condition removed.
Condition that's still conditional.
It's a conditional. In our agreement, we have a 24 hours or 20 hours to give the deposit. When the buyer is not giving the deposit during that period.
No, that's exactly what I'm saying.
Yeah.
The deposit has not been paid and the conditions are still outstanding. If the agreement provides that the deposit has to be paid, I can't give you, it's very difficult to respond to a hypothetical question of this nature. There would be additional questions that would need to be asked. Why is he not giving a deposit? Is it that he has discovered some material fact about the property or about the agreement that he had not been advised of or had not been, made aware of? And he discovered that during this period of time. And he's not paying the deposit for that reason. Then maybe a different conclusion could be arrived at. But if it is not getting the deposit, just because I don't want to pay the deposit, then I think he will be held liable. He will be held liable because the agreement has been signed, the agreement is in writing, the terms of the agreement are clear, he has to fulfill those terms of this agreement, even if he has not paid the deposit. There are several cases like that, the decisions are there, that the judges have found that he would still be held responsible, that he has entered into the agreement, notwithstanding the fact that deposit hasn't been paid.
So basically, with good intention, when you're entering into agreement, it's a good intention at the time of having a mutual mind that we want to buy this property, we are committing to it, so there are good intentions there. And you have to faithfully execute those.
Provided there are no other intervening facts of which we are not. It's a hypothetical question.
Yeah, correct.
I will, you can't give a clear answer to it.
I have another question, is it?
Yes.
Let's assume that a consequence of failed deals, we talk about that. Let's assume we are ready to close a deal, and all of a sudden we learn that the buyer is not able to arrange financing, or the bank has decided to withdraw the financing, and you already have a committed agreement. The buyer has given $20,000, $30,000 to the sellers, is sitting in a trust account, and the seller will have no choice but to resell to somebody. What happened to that deposit, and what are the possibility of, is this deposit forfeited, or do you have to go to the court?
These are clear situations.
Yeah.
It's a breach of contract.
Okay.
The deposit will stay with the brokerage until a determination is made as to what needs to happen with that deposit. It doesn't matter how big the deposit or how small the deposit would be. The buyer who has breached that contract, who has failed to complete the transaction, is definitely in breach of contract. The money will remain with the brokerage. The seller cannot lay its hand on that money unless first of all, if the purchaser is prepared to release that as a damages to the seller.
Yeah.
If that
At Dame Drops told us how good Popeye's buttermilk biscuit shrimp is without us even asking.
So crunchy, buttery, just like those biscuits. Are you hungry yet?
8 shrimp, a side, and a biscuit for just $6.99.
At KM 9000 sang about Popeye's buttermilk biscuit shrimp because he was feeling it.
Shrimp, 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 shrimp. Shrimp, 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 shrimp.
8 shrimp, a side, and a biscuit for just $6.99.
उसके नीचे देखिए कॉम्प्लिकेटेड आपको उसके नीचे देखिए
So, Mr. Qureshi, the money that are held by the brokerage will have to be held by the brokerage until a final determination as to what needs to happen with the deposit. If the buyer does not voluntarily release that funds to the seller, then the seller has no option but to go to court and start a claim. In the claim, the brokerage that is holding the deposit will also have to be made a party in addition to the purchaser. And almost invariably, the judge will grant an order releasing the deposit to the seller.
Yeah, I have right now a case where the buyer failed to bring the funds to close the deal, and the seller sold it to another person and through litigation. So now he has a claim against the buyer in the court of law, and we're waiting for the judgment before the funds are released. Either you have a mutual release, or you can release the fund after the court order. Well, I thank you very much for watching our Realty Coffee Talk. I hope it give you some information and knowledge how to deal with it. If you have any issue regarding real estate, you can contact Mr. Arif Raza. He is a lawyer, a very prominent lawyer, practicing for more than 45 years in Mississauga. And I thank you very much and look forward to your comments, and we will be announcing our next program for next Thursday at 7 p.m. and I welcome your feedback and comment. Thank you. Have a nice evening.
Goodbye, good evening,
Goodbye.
and be healthy.